Mr. J. Christopher, protect the righteous with wisdom and strength.
Listen, brothers, you guys are the gladiators of our business, at least from my point of view, because when something goes down, you don't look for your tax lawyer, you don't look for your accountant, you look for your litigator. You either want to go after somebody's throat in a courtroom or you want to defend your own throat because someone's coming after you, right? So you guys are definitely the gladiators when it comes to legal practice. Hats off to anybody who's in the litigation field and doing it for a living. So let's jump right in because these gentlemen have a lot going on, and we're gonna get started with these questions. So here's a basic question to kind of again warm up our audience and also kind of give you a sense of the direction of our convo. So what acts or omissions? When I say acts, I mean things people do. This is for the purpose of folks who don't know the legal world. Things people do, by their own volition, right? Or omissions, things they should have done but didn't do. So what acts or omissions in media or entertainment transactions customarily lead to a legal action? Whether we're talking about copyright infringement, trademark infringement, breach of contract, what do people do right? I mean, what do people do wrong by their own behavior or by what they fail to do? Typically.
Yeah. Well, I'll jump in real quickly. One of the fundamental problems that I see oftentimes, and remember, we see problems when things go wrong. They're already gone wrong. And one of the consistent things that I see is that people do not lawyer up in the beginning, right? They do not get good legal advice in the beginning, whether that's, hiring a lawyer at all or investing in the right lawyer to help them navigate the legal issues as they're putting a deal together or they are launching into a business or an industry. So I would say, first and foremost, get a good lawyer. And then the second thing I'll say is, one of the biggest issues that I've seen is just basic drafting issues and problems within a contract. Oftentimes I see contracts that are too ambiguous, that do not address the terms in a clear and concise manner, which leads to differences of opinion down the road about what is required to perform. And in addition to that, I often look first in a contract. I mean, a lot of lawyers look at, transactional lawyers especially look at, how much money is going to be paid, what kind of type of credit you're going to get.
That was me, guys. I'm looking at the money.
Absolutely. Yeah. And that's 99.9% of the rest of the world. But as a litigator, we oftentimes look at the boilerplate, what people call the boilerplate. What is the choice of law provision? Is there an integration clause? Oftentimes that's where an attorney's fees provision would be. What form we have to litigate in when there's a dispute. All of those types of issues for a litigator are extremely important and may help to decide what the ultimate outcome is. But also importantly, depending on what those terms are, they may oftentimes help you avoid getting into a litigation situation because it gives you leverage, it gives you other tools to try to persuade someone else not to continue with a dispute. But also, it is the first mechanism we look at to make sure that our client is well positioned, when a dispute arises.
I want you guys to pay attention to what this man said. Lawyer up out the gate, meaning get legal consultation from competent counsel before you press send on that email because you drafted something that has legal implications, or before you put pen to paper and call yourself putting together a contract. Get legal advice or a lawyer to handle it for you. Otherwise, you're going to probably get yourself into trouble if something goes wrong with that particular transaction or deal, right?